Now I'm back home in Africa, and everybody wants to talk about the genocide application brought by South Africa. So, am I right that you'd really like to know about this panel and its work? And the next big case before the ICJ, which follows our recommendation, which would be also live screened on the 19th of February. So this commission with a rather long name, it has a long name because for the very first time it includes Israel. No commission has been established so far that includes looking at Israel itself. All commissions focus on Palestine or Gaza or West Bank, very specific areas. They are also time-bound, usually 1 or 2 years, and they have a very specific map over an episode or other that has happened, such as the closing of the mosque or the chopping down of olive trees. So this one is almost a permanent commission. It doesn't have any cut-off date, so we'll be reporting forever. And secondly, it has a so I already mentioned the territorial mandate, very wide area. The temporal mandate is that we hear almost as a permanent commission. And the mandate to us is that we identify the root causes of the conflict and offer solutions or recommendations. We also have an investigative mandate, which takes us into criminal law, international crimes, not just the international law, such as crimes against humanity, genocide, war crimes. Served. And we have to address past and ongoing conflict or violations of human rights. So you see, it's a very wide mandate. The investigation mandate, gathering and collecting information, sharing them with institutions, identify perpetrators, individual perpetrators. So it's really a wide mandate, as you will see when you look at it. We, by a majority of members of is a subsidiary body of the General Assembly. The parent body has states of the world. This Rights Council has 49 members. It's highly competitive as states compete to get onto this body, because the Human Rights Council this one? The Human Rights Council is based in Geneva, 49 members, as I said, and they pass resolutions, take action on the human rights situation, but they also have a system called the Universal Periodic Review, where they review the human rights records of every state, and other states have an opportunity to make recommendations to that state, civil society from the country concerned, and also all the UN agencies contribute. You know, I'm jumping in here to tell you about UPR, the Universal Periodic Review, because I noticed in these engagements recently that people don't seem to know about UPR. Why do I mention it? Because that's an accountability mechanism. The most frequent question is, so what do? You pass a resolution, states are not implementing it. So that's a very important element. I'm telling you this because I served as High Commissioner for Human Rights, and in that capacity, I had the power to set the agenda and initiate discussion by states. Anyway, I'm out of the position of High Commissioner for Human Rights when I was called by the President of the Human Rights Council to serve on this commission, and I'm very pleased to say that Chris and I have worked very well together so far.
So far.
Yeah. There's one matter we don't talk about, and that is that Chris served and still serves as a commissioner on the commission established by the Human Rights Council in respect of Myanmar. And I was nominated by the Gambia to serve as ad hoc judge in that matter because the Gambia was bringing this complaint against Myanmar for violating the Genocide Convention in respect of their treatment of the Rohingya Muslims. And the Gambia didn't have a judge, just like South Africa didn't have a judge this time. Now we have from yesterday. And so my friend and colleague Digtang Moseneke served as ad hoc judge. So I'm ad hoc judge on that matter, and really between us, we do not discuss Myanmar except when it came to legal findings and so on. This adoption of the resolution in the Human Rights Council setting up this commission was opposed very strongly by the United States and Western countries in Europe. And their complaint was that it doesn't have an end in sight. You can't have a commission that's permanent. And they objected to the mandate. So when I was defending the situation after becoming chair, I pointed out there's 2 or 3 other commissions in respect of Syria that don't have an end date. And that you, United States, you are supporting that. You're voting for that. You're paying for that. So it's my way of indicating, listen, can we have principal standards? Yeah, not double standards. Until we got, we report before the Human Rights Council in Geneva every June, and we report before the General Assembly in the United States every October. So we've planned our entire work, well, as far as we could, on how we're going to deliver on this mandate. So when we delivered our first report before the General Assembly in October 2022, we said, based on all the circumstances, the factual situation on the ground, and all the international law, including interpretations from the International Court of Justice of this body of international law. We quoted that jurisprudence, and we said, we say that the root cause of the conflict is the occupation because of its perpetuity. So that's what the court will consider on the 19th February. So you'll be surprised to know, this is the first time that the International Court of Justice has been asked to pronounce on that matter. I think it's like 50 or close to 60 years of occupation. And I feel good about it because we made a very convincing case, not because we thought so or some emotions or we were taking sides. No, just based on the facts on the ground, supported by all kinds of authorities and the law as we saw it. So we were convinced, but we are only a commission of inquiry. And this is, you need the weight of the opinion of the highest court in the land. A court, as you know, which is only available to states parties. It's not for you and I. We can't access that. So it's their court to settle their disputes. South Africa brought its application as a dispute between 2 states. If the General Assembly refers this, then it's the General Assembly's request to the court. Our court, give us an opinion on this. So it's an advisory opinion. It can only be implemented by going back to the states, to the Security Council. And so the resolution at the General Assembly was equally divided. So almost 22 states from Europe, United States, Israel voted against this referral to their court, but 87 states voted in favor. So that's why the matter is now before the court, and let's all await the judgment of the court. Chris will give you a better idea, but I'll stop there then. Thank you.
And I too will keep it short. We'd like to hear your comments. Obviously, we'd like to respond to your questions, but particularly we'd like to hear your comments. Navi described how This commission has been opposed by many states because of its unlimited mandate. It is not time specific. I don't see it, however, as a commission forever. I mean, those who would like to get rid of the commission can do so very quickly and very easy by fixing the situation once and for all. So we anticipate that we'll go out of existence at some stage in the next 2 or 3 months. We are a law-based commission. Our concern is not politics, the politics of the dispute, nor is our concern, as strange as this may sound, nor is our concern with the morality of the dispute. Our concern is with the law. That doesn't mean we're not impartial. We are very partial. We're not pro-Israel and we are not pro-Palestine. We are pro-international law, pro-human rights, pro-international humanitarian law, and it is that partiality that we bring to bear in undertaking the work that we have been requested to do. One of the advantages in not having the limitations of past commissions is that we can look at the picture comprehensively. I mean, past commissions have been time-specific. They have been geographically specific. They've looked at only Palestine and not at Israel, and yet we know that there is a full picture to be examined and understood here. Past commissions have been episode-specific. They've looked at a particular series of events in Gaza only in some respects. At the Great March of Return, for example, in 2018, or the hostilities in Bet Hanun in 2008. We have an opportunity of moving beyond time, beyond geography, and beyond incident to develop a comprehensive picture. In approaching our work, therefore, we are trying to build an understanding of the total situation. We deliberately refrain from providing day-by-day commentary on events as they occur. There is a special rapporteur on the OPT, Francesca Albanese, who does an extraordinarily effective job, who is involved in following events on a daily basis and commenting on them on a daily basis. Because Francesca does that, we have the benefit of being able to sit back and to approach our job comprehensively and thoroughly, regrettably slowly, because since we are an investigative body, we have to investigate. You know, our job is to get the evidence and make conclusions about the evidence. And having done that, ask the question, what is the law that applies to this body of fact as we have found it? And then on that basis, to make findings and recommendations, not as a court, but as an official UN investigative body. So our fact-finding is thorough and it can be time-consuming, but it's not superficial, and it presents in our reports a well-documented, evidence-based, legally analytical picture and understanding of the situation. Navi has mentioned that we report twice a year, and that is the principal means by which we speak, not on the basis of daily commentary. We report each June to the Human Rights Council, each October to the General Assembly. And our reports are trying already to build the picture and will continue doing so. We were specifically asked to analyse past UN reports of commissions of inquiry and rapporteurs to present a picture of the fundamental issues that those reports have identified. And we did that in June 2022, and we said that occupation and discrimination were two issues that were the basic issues identified in past reports and issues that we would examine. In our next report, we indicated that having looked at the evidence, we have come to the conclusion that the occupation is unlawful. And as Navia said, that has resulted in the request to the International Court of Justice for an advisory opinion. We looked in June last year at restrictions on civil society in both Palestine and Israel, using the geographically comprehensive mandate that we have to draw the commonalities in the activities of the three authorities, the State of Israel and the Israeli government, the Palestinian Authority in the West Bank, and the de facto authority Hamas in Gaza, and how they are treating civil society. We looked further on that issue in our report to the GA last year, and examined specifically the targeting of journalists and the killing of Shireen Abu Akleh, and also the impact on women and gender-based differences in the way in which particularly women journalists were mistreated, there's no other word for it, by the Palestinian Authority and targeted by many of the trolls in Israeli associated websites and activities. So trying to present a comprehensive picture outside of the geographical barriers has been an important part of the work that we do. It had been our intention to turn to discrimination in our reports this year and next year, and we'd planned our work before 7 October occurred. But now this year, that is the exclusive focus of our work. What has happened on and since and is continuing, on and since 7 October and is continuing, is of such seriousness that that is the entire focus of our concern at the moment. And our reports to the Council in June and the General Assembly in October will deal with the evidence that we have gathered and with the conclusions that we draw from that evidence through the application of law. I think that's probably enough, and I think we should hand it over to you.
Yes, he deserves a clap for that. I might have forgotten to mention to you that actually the General Assembly has sent 2 questions to the court to decide. One is the occupation lawful or not? And 2, what are the responsibilities of states towards an unlawful endeavor? So you could see how important that second question is.
So in terms of discrimination, I've looked at the reports, and apartheid appears in your footnotes generally, and not as a word used as leverage in the context of what is happening. And could you explain why you've shied away from using that word?
Chris loves that.
Oh, thanks.
We've shied away from using that word because we haven't yet done the work. And we're not going to use any words just for the sake of using the words. There has been excellent work done on the question of apartheid by Yashdin in one of the Israeli organisations, by B'Tselem, another Israeli organisation, by Human Rights Watch and by Amnesty International, among others. Breaking the Silence, another Israeli human rights organisation. Al-Haq, Palestine Centre for Human Rights. So many organisations are working on this, and we are aware of their work and will analyse their work. But one of our responsibilities as an independent commission is to form our own conclusions and not just endorse the conclusions of others. The broad framework of discrimination is the framework in which we will have to address this question of apartheid. So it's not that it's not on our agenda, but we have not yet done the work, that's all.
Thank you. The General Assembly back in 1947, with Resolution 181, approved the partition of Palestine by a vote of 33 to 12, I think it was. Obviously, that was ill-considered, given the circumstances that have arisen since, including the Nakba and the occupation and so forth. Given the membership now of 193 countries, would it be possible for a resolution to be passed at the General Assembly in 2024 to revoke that Resolution 181 and thereby make Israel's existence a question?
You go first.
The beauty about being chair, you delegate. The Security Council passed two resolutions that creating the state of Palestine, but also saying there has to be a state of Palestine, a state of Israel, and also Palestine. They have not delivered on the second one, and they're doing less and less to protect the rights of Palestinians. So, but as our historian,
you use the expression obviously ill-considered. I'm not going to use that expression. You know, we're a UN commission, and so we will build on the decisions of the United Nations, and it may be that it was ill-considered. And in fact, there is a book coming out, I think, this month by Dr. Adi Imsens, an academic at Queen's University in Canada, who is looking at Resolution 181 brackets 2 close brackets, and his view on whether it was within the power of the General Assembly and its legal validity. And it's going to be a very interesting book. The General Assembly, I guess, having passed the resolution, can decide to adopt another resolution if it so desires. Perhaps the two and only 2 points that I would make are, Navi has already referred to one of them, that it's only been partially implemented. One interesting question that I have is that and it's only a question, that the Prime Minister of Israel, Prime Minister Netanyahu, 2 weeks ago said that the Israeli government will continue to control security in all lands west of the Jordan River. My question about that is, firstly, does that represent a repudiation of Resolution 181 brackets 2 by the government of Israel? And if it does, and I have no answer to this next question, if it does it, what is, if Israel repudiates that resolution, what is the legal basis for the existence of the State of Israel? Now, that's a question that is raised by the statements of the Prime Minister of Israel, not by me. But it's an interesting question. The second point that I would make is that having passed Resolution 181 brackets 2, the international system in 1947 took responsibility for the situation in what is now considered Israel and Palestine. And having taken legal responsibility at the start of the current situation, it cannot now walk away from continuing legal responsibility for its resolution.
Hi, I'm Karen, and not such a big legal question from me, but just, the UN and everything that you explain, I mean, for us as citizens, as civil society, feels very far away. In your discussion, you spoke about the role of the state and that it is states that bring things, that it is the General Assembly that can ask. But in all of this, what is our role, and what power and what mechanisms do we as individuals, as collectives in civil society, as citizens, as residents, how do we engage with these bodies in order to maintain accountability, and particularly, particularly if you're living in a country that is not adhering to resolutions or adhering to laws, and also, do we all need to really understand? What I found particularly useful in the recent ICJ judgment was how simply and clearly all of the documentation was written and how it was delivered. But I think for, I don't know how other people feel, but I assume that many people feel intimidated by this system. So, yeah, what recourse and what role is there for us? Thanks.
As I said, as faulty as it is, as defective as it is, this is the mechanism we have, the United Nations, for multilateral discussions with the sole goal of maintaining peace and security, which power is invested in the Security Council. And as you know, it's a Security Council that makes the ultimate decision on what kind of interventions they would make. What's our role is, firstly, we excluded from the decision-making in the United Nations. But let me say, as former UN High Commissioner for Human Rights, nothing changes without pressure from civil society. So it was because of ordinary people demanding accountability for human rights violations, for instance. This was at the Vienna Conference on Human Rights in 1993, where civil society dominated that conference and demanded that the UN set up a Human Rights Commission to make sure that human rights protections are implemented. I was a member of an NGO in those halls. We didn't have access to the government decisions upstairs, nor did I, coming from South Africa, we still haven't achieved our democracy, nor did I have access to these big, powerful NGOs who had their own hierarchy. So from that helpless position, civil society succeeded, and the General Assembly set up the Office of the High Commissioner for Human Rights, and I think I was the fifth High Commissioner, but the only one from the developing countries, the only one from Africa appointed there. And the High Commissioner works very closely with civil society, holds discussions. They can make presentations in the Human Rights Council. So we work together. I've always said so many of the changes were brought about by civil society pressure. It's not that governments woke up one day and decided, oh, maybe we should be more accountable. If you take development alone, nothing was being, which is a developing country issue. There was great resistance from the rich countries when I started. One of my first missions was to Germany, and the minister there said to me, there is no such thing as right to development. That has to come up from the ground. So in other words, they wanted it so that governments will think they're doing us an act of charity by giving us livable pensions or delivering clean water to us, many issues like that. And so in the human rights world, civil society noted a skewed emphasis on the demand for civil and political rights, much loved by the West because they think they've achieved that through their centuries of civilization, and that they must now see that civil and political rights are respected in all parts of the world, and less attention to economic rights and development. In my first conversation with the head of WHO, the World Health Organization, and I told her that health is a human right, and she literally threw me out of her office saying she will be in big trouble with her board if she speaks of health as a human right. So do you see how governments suspect the rights language? And we are so used to citing rights in our constitution, rights in international law in many parts of the world that are not democratic. They don't have that scope. So let me say the duty then is on each one of us. The duty bearers are the states, but we are the ones who have to push and pressure for these rights. As we did in development, where we when they drew the Millennium Development Goals before I got there, the states absolutely refused to use two words there, human rights. And so they had targets, save 50,000 women from maternal mortality. What about the rest of the women? Well, let them die. So along comes the development document called Agenda 2030, which has human rights in 8 places. Lots of hard work from civil society and the Office of the High Commissioner for Human Rights. And that's where it's written in that document, you leave no one behind. So it's human rights for everyone, economic, social, and so on. The dismal news is that states haven't lived up to their pledges of support. So I'm going to leave you with that answer that we have to make our own government accountable. We have to know how they're voting in these international institutions. And we have to be given explanations for the positions that they adopt that are contrary to our Constitution. Yes?
I'd like to respond from my perspective as someone who has principally come at this from civil society. I mean, that's my background, not government. When you say people feel intimidated by this system, my response, I have to say, is to ask why. If the system were functional and effective, well, then maybe we should feel intimidated. But it's not. The basic question for me is the question that every civil society organisation and every civil society activist has to ask. And that question is this system worth an investment of my time and energy? And many civil society people will say simply no. But I agree completely with what Navi says, and that is that the improvements in the system, the development of law, and the strengthening of mechanisms have all been direct results of civil society engagement. The Declaration on the Rights of Indigenous People is the product of Indigenous groups making the system work better. The Convention on the Rights of People with Disability is the direct result of disability rights groups putting pressure on governments at home and the international system abroad to address the rights of people with disability. Navi's referred to the Vienna World Conference and the office that she held as High Commissioner. That was an initiative first of Amnesty International that was then picked up by Human Rights Watch and by literally thousands of NGOs. So there's no basis upon which there should be a sense of intimidation, but every basis to feel frustrated and to say, I have limited time, I have limited energy, I'll invest it elsewhere. The fact, though, that the system is struggling to respond to some issues is only because of the pressure that civil society groups put on it. And that applies as much to this issue as anything else. Civil society groups in Geneva pushed for the establishment of our commission, as for previous ones. Whatever value there is in the system comes as a result of domestic pressure on governments and international pressure from civil society organisations on intergovernmental institutions. So don't feel intimidated, but there is value in investing here, and there are expert NGOs that can help civil society groups to engage productively. I spent some of my time some years ago in one of them. So if you want to invest, don't be intimidated, but it's a strategic decision, to recognise this is what we want out of the international system and this is how we're going to get it. It is possible.
Hi, thanks. Hi, Navi and Chris. Reading the ICJ judgment, I wanted to address Terry. Let's go back to 1917 and the Balfour Declaration instead of starting with 1947. In 1947, during the debate in the General Assembly, the American diplomat argued that this decision on creating the State of Israel was a small injustice to address a larger injustice. And, how do we feel about that? So let's go back to 1917, the Balfour Declaration, quite frankly. But the question I had for both Navi and Chris is, reading the ICJ judgment, and, it makes reference to a lot of statements that have come out of UN agencies, et cetera, et cetera. Was there anything in that judgment that uses any statement from your 4 reports to kind of reinforce what the agencies are saying? Would be one question. The other is the point that Chris and Navi have made about your mandate, the fact-finding, the investigation, etc. And knowing that Israel is not going to give anyone entry to come and do investigations. In 2012, I was refused a visa by Israel to conduct a UN mission. And the Minister of Foreign Affairs or Justice said that she had asked to go to Palestine, and there's no such state, and there will never be such a state. And this was in 2012. So how do you do fact-finding? And I was reading I suppose it's the opinion of ad hoc Judge Barak, the Israeli judge. And in it, he distinguishes the evidence that was placed in front of the Gambia court, the court that deals with the Gambia case, and says there were 2 reports that he was prepared to accept the evidence. But on the South Africa case, the evidence was flimsy because it was citing Israeli politicians, UN agencies, etc. And so how, if you're not allowed to go in to do your fact-finding, your investigations, will we end up with a judge, because a Ugandan judge is now the vice president of the ICJ, which is so ironical. If you're going to get that caliber of judges who are going to dismiss evidence because your commission of inquiry is unable to go and conduct the kind of fact-finding and investigations, what do we do then?
Rashida, when you said ICJ judgment, you mean the provisional orders? Yes. So they wouldn't look at our reports. They will look at it from February. Well, they've looked at it already. There'll be here arguments on February 19th in regard to our reports. I still sit as a judge on the Myanmar case. We very much relied on the facts found by the Commission of Inquiry. That's the one Chris sits on, and you've heard him. He's just very, very careful about how they gather and collect facts. About Judge Sebutendi, well, it would be improper for me to comment, except to say, 1, I don't agree with her judgment, and 2, why do we think it's always a good solution to say, put a woman on the bench? And of course, yes, well, we've read the dissents. The important thing is South Africa won its case by an overwhelming majority with 1 dissent. And they did so by gathering the facts. And one of the key bodies they get the facts from are UN agencies, not only our commission, but people like you when you were special rapporteur. How did you gather your facts and verify it, make sure? Because people want to talk about what's happened. So this commission was since we were not permitted to enter Israel and were still to enter Palestine, which is supposed to have status as a state, Israel even wouldn't let us in, and Egypt wouldn't let us in through the Rafah gate. And now, who said it? Was it Netanyahu that, yes, that they're going to exercise firmer control over the Rafah gate. But the Israeli lawyers said Israel has no control over that entrance, that Egypt has the sole mandate. Yeah, that's not true. Because we're not allowed in there and don't have access to the victims and NGOs, writers, academics inside, we make a point of being much more careful with the evidence. We just don't repeat something because somebody else said it, yeah? We're not Fox News, yeah? Or some of the states. So you should see, yeah. So to us. The United States says, yes, well, we don't support you because you shouldn't be permanent. And then the next speaker, all their pals, read out the same speech. So it's a crazy situation. We have managed to bring people out of Israel, out of other places. Firstly, academic experts are crucially important because they've been carrying out research and facts. We call activists of all kinds, both pro-Israel and pro-Palestine. We don't just select the one side. We want to hear you all. And you should see how one lot gets convinced by what they're hearing in the room from their colleagues. It's a huge responsibility for the Commission to make these very firm conclusions and to make a recommendation that will convince states to do something new here, get an opinion. Yeah, we wouldn't do that on our own without wide consultations. Most importantly, are people who came out of Palestine at great risk to themselves. They were searched and stopped at that Egyptian border, harassed, really upset by the time they came to see us. So people are very, very willing to come out to see us. We call for submissions. We get submissions from everyone. And then we verify those facts, of course. Lots of research done by the team. But mainly, as the court did in the South Africa case, who did they cite as authority? The work of the United Nations. Because you can trust that they're like the Secretary General. It's not just his personal opinion. There's a wide history behind them, lots of research, lots of input from heads of all other agencies. And so I'm very happy that the court cited these statements as authoritative of what's happening there. And more importantly, the seems to have done their own research, and they quoted statements made by Israeli authorities, like up January 17th. So that's long after South Africa filed their papers. So some of the facts on the ground they relied on came to them directly, or they heard it from some reliable source. So I'm very hopeful. I don't know what was Rashida's further question.
Yeah, can I? Just, again, adding one point to what Navanethem. The biggest difference between the Myanmar case and the Palestine case, or the Gaza case, is timing. The Myanmar case was started after the major period of the clearance operations had been completed, which was the second half or the second last quarter of 2017. The Myanmar fact-finding mission gathered evidence between 2017 and 2019, produced its reports, 1,000 pages of reports by the end of 2019. The case started 2020, the provisional measures were decided 2021. By the time the court in the Myanmar case came to consider provisional measures, the reports of the Myanmar Commission had been around for a couple of years, and they had them all. This case is occurring much earlier in the story. The situation started in October. It was heard in early January, and it's continuing. And so the court doesn't have our investigative reports yet because we haven't produced them. We're just at the early stages of it. By the time we get to the end of the year, there will be voluminous material available in our reports that the court will have to deal with. Now, two of the judges, Barak, the ad hoc judge, and Nolte, both referred to the huge volume of material on the Myanmar case and how important that was to the court. So I think that they'll be very impressed by the time they come to consider the merits of the South African claim, to have an equally voluminous amount of quality material from us. And they'll have to take it into account because particularly Judge Barak from Israel has talked about how important the material from the Myanmar Commission was for the Myanmar case. Well, I've got no doubt at all that he'll find the material that our Commission produces just as important when he comes to make the decision on the merits.
Thank you for this opportunity to ask questions. And a special tribute to Navi, who has been our role model as a South African activist, and to where you are now, and that we actually have now access to the UN. My question, and I'm extremely distraught at the fact that there is no ceasefire. Okay, and that there is pressure now to urge states to pressure the ICJ for a ceasefire. I'm a paralegal and I have to represent gender-based violence in terms of domestic violence. And logically, there is a protection order in terms of the violent situation. I do not understand the whole issue. We cannot appease to the conscience of the perpetrator to end the violence and the violations. And I am extremely concerned that there is no international court order for a ceasefire. I think we need some clarity on this, because we do understand international global capital at play, but we still need to understand this in terms of international law. Thank you.
Thanks very much. I think the concern I have is really around the timing and how do we, so legal processes take place in the context of power. And with Ukraine, there's a very big difference in quick response compared to Palestine. And the issues there then that raised, I'm going to pick up on the issue of the ceasefire and how do, who does stop the arms trade? Because unless that's stopped, the bombing continues, the weapons still keep flowing in. And the issue of, in terms of power, the UN Security Council then having the right to veto means things get blocked. And what's the way past that? And yeah, I suppose I want to look at also how, in looking at the reform of the UN system and the Security Council, is also to look at the incoherence between human rights law and issues around trade law, for example, and the institutions related to those. Thanks very much.
It's a very specific question. It's my understanding that in 2003, the ICJ had already issued an opinion regarding the illegal construction of the wall in occupied territories. And it's my understanding that in part it had addressed part of this question, but I defer to your, far deeper knowledge on the topic. And I would just be interested to know what, in addition, would, is this taking it further? Is it further emphasizing? Is it clarity? Is it partly because the wall was only in the West Bank? Yeah, thank you.
We will each take a little bite of the answers, and Chris will do the same. Why no ceasefire? I was right there in UN when, by the way, we issued the first statement by a UN body calling for a cessation of hostilities. We had done that by October 11th, just 3 or 4 days after the 7th. We called for a cessation of hostilities. We called for a return of the hostages. We called for protection of civilians. I think there was a fourth thing that we called for. And then also, to my horror, 11 days later, the Security Council had still not made a decision on ceasefire using that language. And the United States used its vote to stop the unanimity that it the support for ceasefire existed amongst other members of the Security Council. But bottom line for us, no ceasefire. Their reasoning was, if we agree to ceasefire, then Hamas wins. The Secretary General told us that the best concession he was able to get is the language humanitarian pause. Now, and he said to me that that can be interpreted as ceasefire. Clearly, it was not interpreted or implemented anything close to ceasefire. There was a minor pause, and the killings and violations continued. Why no ceasefire order from the court, the ICJ? Well, I believe the South African lawyers didn't actually ask for a ceasefire. They asked for a suspension of the military operation. The court didn't grant that. Actually, the court hasn't granted that in other decisions on the same issue. They are much more specific. You know, you have to prevent the commission of genocide. And as you know, you have to provide, allow humanitarian aid to go in. So they were much more specific. The best explanation I could give you why the courts do not order ceasefire is because they can only order a state to carry out something that is their legal obligation. So as the occupying force, Israel is under legal obligation to ensure humanitarian aid reaches. So that's a legal obligation. And as a signatory to the Genocide Convention, they have a legal obligation to prevent genocide. So that's what the court ordered. Ceasefire is not in the language of any of these treaties, but it's the language of member states, military language, but it is something that the political organs, the Security Council and General Assembly should have adopted without hesitation, because we were all seeing these killings and health deprivations on our screens. Pregs, on the timing, yes, we all note the very quick way in which the ICJ was seized of the matter in Ukraine, and the very quick way in which the prosecutor Karim Khan of the International Criminal Court has acted in investigating the situation in Ukraine, whereas that prosecutor was sitting with the Palestinian complaint for 3 years now. We did have meetings ourselves with the prosecutor. I wish we had something better to report to you, but at least we minor pressure point, but also offered our help to share information with them. We are not saying that it was wrong for the ICC or the ICJ to act so fast on Ukraine. It's right that they did so. They must adopt the same standard and procedure in respect of Palestine. Right. I don't know what you wish me to say about the veto and the reform of the UN Security Council. NGOs, and plus many, many states are heavily involved in that issue, including me. As High Commissioner for Human Rights, I had the privilege of addressing the Security Council for about 15 times, more times than all the High Commissioners put together. Because I said, how can they decide on peace and security matters without taking into account the human rights violations on the ground, because that feeds into, it alerts you to bigger things to come. But I'm sorry to say, as soon as I left, they stopped my successor, Prince Zaid, from addressing the Security Council. He was so cross. He went to the press about it. It didn't help him. We definitely should support the reform of the Security Council. And South Africa is a leading player in leading this process on behalf of Africa for this reform. And I know that at least 60 states submitted their signed document to me, which I was able to quote to the Security Council. So they all want reform. Who doesn't want the reform? Are the 5P5 who hold the veto. So if there's one thing they're all agreed on and are unanimous, that is they will not give up their veto. So I'm sure there'll be a great deal of discussion on this, especially when they're looking at a humanitarian situation, human rights situation, and a situation as is ongoing now in Gaza. So you're quite right. In 2003, 2004, there was a wall case. That's the case we relied on to pick up what the court was inferring there. The court was not addressing occupation. There's no decision or sentence from them that the occupation is unlawful. What they said in the wall case is where the court found that it was acting unlawfully in building this wall on, and they ordered the removal of that wall, and true, the wall is still there, so it hasn't been complied with. But the court made some significant statements that by building a wall on Palestinian territory, they were boots on the ground to make occupation permanent. So that's where we grabbed this. This is a good opportunity for the court to now address the main issue of whether the occupation itself is illegal. So that's how it is, taking it further, right?
Thank you. I have, maybe it might seem like a slightly personal question, but not just with regards to your engagement with what's happening in Palestine, but the histories of both of your work and what type of work you do requires you to engage with, stories of deep suffering, engage directly with people who have suffered unimaginable hardships. And part of that work, in order to be successful in it, requires you to be empathetic, caring, try and comprehend the extent of that suffering. At the same time, you have to engage with states, as part of the UN machinery, in which you are faced with, sort of ruthless indifference by some states to the lives and the real humanity of people. How do you manage that? How do you manage to keep engaging and coming back to this work while still being able to sustain it? I think, working in many different areas in civil society, that can be a big question. And the work that you guys do, I can imagine you've had to grapple with that. Yeah.
Hi. So as people who are passionate about international law, I think one of the biggest criticisms in contemporary discourse is about its enforceability or lack thereof. And so my question is, in light of Israel's defiance of the protective orders, or rather the provisional orders, in light of the West pulling out funding for UNRWA, can we still view the UN, the ICJ, as legitimate institutions, and more importantly, can we still view international law and international humanitarian law as a mechanism to achieve justice, or should we kind of view it for what it looks like it is, which is it's setting a moral and perhaps academic precedent, but it's really toothless in its ability to save lives? So that's my first part, and my second part is, can you maybe comment on the legitimacy, or how you see the legitimacy of these institutions relating to the global south? Because I think that's where this discourse is mostly being had. Thank you.
How do we sustain our work through all the pressures? The commissioners do not get paid, so we are volunteers. We get our travel and an allowance. We prefer it that way. I think it bolsters our integrity and our interest in seeing justice and accountability. So once we agree to do this, we become unstoppable after that, and we attract a lot of abuse. And thank you very much for caring about us personally. It's unbelievable. Of course, some people receive threats, but we've received a lot of abuse, being labeled anti-Semites. New York Times asked me, for instance, how I feel about that. I don't know why he thought I'm going to shedding tears about that. I said, firstly, I'm not anti-Semite, and I find myself in very distinguished company because the UN itself is declared anti-Semite, the Human Rights Council, the Secretary General, the ICJ? Yes. But it's the misinformation, twisting our words, false propaganda, that's about the worst. And no, that's not the worst. The worst came when we were delivering that report in October 2022, and we were abused in the General Assembly by the Israeli ambassador and a few of the supporting member states. And they had demonstrators holding up posters with caricatures of us, accusing us of all kinds of things which were not correct, but that they were allowed to do that. So there we really acted. The UN style is to maintain a tight lip, dignity, say nothing. It's not my style. So we went public at a press conference at the UN, saying that here we are volunteering our services. We asked to come and report at the GA. The General Assembly must ensure that there's a safe space for us to do the reporting. And this has never been allowed. Can you imagine civil society organizations are not allowed to even enter that room, let alone hold a poster or a banner? And yet this one country is being allowed to do so. What happens is the presidents of the General Assembly, those committees at the General Assembly and the Human Rights Council, they let the ranting go on, and then they timidly say, you know, try and keep to the substance of the report, don't become personal. Yeah, but the damage is already done. Honestly, I was there for 6 years. I've seen all this happen. So this is why I was able to say, and we followed up with very firm letters to the presidents of the GA, Human Rights Council, and the Secretary General, which letter somehow got leaked to the press. I didn't mind. It was useful for us. So when we delivered our report in October 23, yes, we didn't hear a meow, did we? Yeah. So we missed the action, but we got our point across. So what am I saying to you? Yeah, we all get vilified for the positions we adopt as human rights defenders. You do. You have to tell yourself you're on the moral high ground, and you have to do this for all those people who cannot speak for themselves. So that's the way we deal with pressures. Non-implementation by Israel, and whether all these international institutions are genuine, whether they are flawed. Yeah, as I said, don't even ask me. I was an insider there. I mentioned that they deliberately stopped the inclusion of the word human rights in the development document. And when I got there, I did a lot of work inside the UN and reminded all of them that the United Nations is a norm-based institution. It's a responsibility of everyone, not just the High Commissioner for Human Rights, to uphold human rights. They all have to do it, whether they're working in development and so on. These are the agencies within the UN. They all worked in the separate silos. Notice the Margaret Chan, the head of World Health Organization, said straight to me, she's not going to call health a human right. You know, we then established regular communication at what we say working level. So who was then talking about health as a human right? Margaret Chan. She gave me a lecture about why health is a human right. So change is possible if we persist. These institutions, I really look forward to young people, the next generation, to confront things that have not been confronted before. And that is, we're sitting with an international institution fit for post-World War II, giving the victorious powers the veto, which victorious powers, China added later, are refusing or are using the veto against the Charter, the principles of the Charter of the UN. And so when I was High Commissioner for Human Rights, I was able to tell them to their face, this was an informal hearing of the Security Council, I said that Margaret Thatcher and Ronald Reagan, UK and US, you used the veto in favor of racism. And the UN Charter prohibits racism. So when you have the opportunity, speak out. You know, there's very little they can do to me now. I'm just too old and won't go away, so. But I ask you to be careful. You want to continue as a human rights defender. And think of all those human rights defenders and journalists who are in jail, sometimes for 18 years just for writing an article. So don't take risks because you are more useful outside than inside prisons.
Yeah, I think thank you.
You've both asked very personal questions, so let me give a very brief but very personal answer. I mean, your question basically boils down to, how do you cope? Why do you keep going? For me, there are three key principles. The first is that whatever I experience is nothing compared to the experience of the people who are the victims. The impact on me is trivial compared to the impact on them. The second is that what I experience is no different from what you experience. And civil society activists everywhere keep on going. And so I'm just in the same boat, nothing special. And the third is that in the end, it's not up to me. I'm not going to make it right. I contribute my small part. But it doesn't depend on me. It depends on a hell of a lot of people. And I want to contribute along with them. And the same applies to international law. As I said earlier, it's a choice about whether we're prepared to invest in this or not. And a lot of people make a very sensible, rational decision that it's not worth the effort. That's not the decision I've made. I have said before, I keep saying, international law is the only thing that stands between us and the abyss. As weak as it is, as ineffectual as implementation is, there's nothing else. And for me, I'm prepared to invest in making it work better.
Thank you, and I think that beautifully summed up, I think, this evening and what we all should try and achieve, and everyone should continue doing their little bit in the hope that we do make a difference. So go out there and keep fighting the good fight. And thank you so much to the commissioners.